Okay, thank you, Your Honor. Professor Callanan, when we left off, I had asked you a question about whether there was a pattern of preference in the voter IDs that North Carolina accepts under SB 824. And I just wanted to make sure you had completed your answer, and if not, give you an opportunity to finish.
Sure. So I had mentioned government employee IDs, college student IDs. My report also discusses expired IDs. North Carolina accepts expired IDs at least up to 1 year past expiration. Certain forms of ID can be held regardless of expiration date, such as public assistance IDs and military IDs. But expired IDs have been looked at. The racial demographic of expired ID holders has been looked at by a plaintiff's expert actually in the federal challenge to this case, to this law. And what he reports is that African American registrants and voters in particular are more likely to hold expired DMV ID in North Carolina than are white voters. And North Carolina, again, accepts expired IDs up to 1 year past expiration date. I also look at tribal IDs. This is a fairly straightforward instance in which North Carolina accepts a form of ID that a number of other states reject, and this form of ID is held, of course, 100% by members of a racial minority. I also look at public assistance IDs, which African Americans and racial minorities generally are more likely to hold in North Carolina than are whites. You can also look at two other categories, veterans IDs and military IDs. Veterans IDs are a mixed bag. African Americans are actually just as likely to hold a veterans ID as they are to be registered to vote, so there's parity here. Hispanics are less likely to hold a veterans ID than they are to be registered to vote. So this, you could say, would be a kind of mixed case. Maybe it's it's difficult to say whether we want to regard this as fitting the pattern completely that we're looking for. And then finally, military IDs we do find are more likely to be held by whites than by members of racial minorities. But taken as a whole, as you can see, we don't find a pattern of preference for IDs that are more likely to be held by whites.
And are you familiar with the rebuttal report submitted by Professor Kevin Quinn, in which he criticized your assessment of the IDs accepted by SB 824?
I am.
And is there anything you would like to say in response to that criticism?
Well, Professor Quinn's view seems to be that analyzing the structure of the law in comparison to the structure of other state ID laws is not as interesting as the analysis that he's undertaken. But I think he put it well in his testimony, which part of which I briefly saw, which is to say these are different enterprises. So he is engaged in an impact analysis, whereas I'm engaged in a comparative analysis of the structure of the laws. My own view is that his impact analysis really ends up being at most half an impact analysis because it doesn't account for the effect of the reasonable impediment option, which is a major distinctive of the North Carolina law and would certainly shape its impact on voters. But these are different enterprises, and both are of some value.
And if you weren't doing an impact analysis, what is the analysis that you were attempting to do by looking at the racial characteristics of possession of these forms of ID?
Well, in the first instance, I'm providing a comparative analysis of the structure of the laws. And one of the hypotheses that has been floated is that discriminatory intent, what might it look like? How might it surface in the law? Well, one way it might surface would be in the form of a pattern of preference for IDs that are more likely to be held by whites, and a pattern of disfavor for IDs that are more likely to be held by racial minorities. And what I find is that pattern is not present. Does this allow me to draw any final or global conclusions about intent? No, and I don't do so in the report. My goal is much more modest, to analyze the comparative structure of the laws, and my understanding is that determinations of that sort would be legal determinations ultimately.
And do you wish to change anything about the opinions you have offered in light of Professor Quinn's criticisms of your analysis?
No.
And are you aware of the rebuttal report of Professor James Laludis criticizing your conclusions about the leniency of SB 824?
I am.
And what would you say in response to Professor Laludis's criticism?
His criticism appears to be to the effect that it's difficult for some people to obtain compliant ID, even with the provision that North Carolina has made. He mentions various sorts of costs or obstacles or impediments that might stand in the way of an individual obtaining these forms of ID. And my response to that, I think, would be that I think it would be helpful if he had accounted for the way in which the reasonable impediment option might affect his analysis. If a voter finds that it's difficult to obtain compliant ID, either at the DMV or at the County Board of Elections, this particular law, unlike a number of other voter ID laws, simply allows the voter to say on the reasonable impediment form, I encountered, I was too busy, or it was too costly, or I lacked transportation to obtain ID. So all of the obstacles that he mentions would be consistent with or covered by the reasonable impediment option. I'm sorry for interrupting.
No, I'm sorry for interrupting. Does anything in Professor Laludis's report cause you to change the opinions you are offering in this case?
No.
And now I'd like to turn to the third category of interest that you discuss, and that is the interests that advocates of voter ID laws have advanced for those laws. How would you describe the state interests that advocates of voter ID laws normally identify in support of those laws?
The interests normally identified are those in Crawford, actually, combating fraud and guarding public confidence in elections, and then more rarely and somewhat abstractly modernizing elections. But the first two are interests that I address in my report.
Okay, and I would like to bring up LX1, and this is the 2005 report of the Commission on Federal Election Reform entitled Building Confidence in U.S. Elections. Are you familiar with this report?
I am.
And you considered this report in connection with your testimony in this case?
I did.
And what was the Commission on Federal Election Reform?
It was a commission led by former President Jimmy Carter and former Secretary of State James Baker. And it essentially assembled a sort of blue ribbon group of academics, statesmen, and civic group leaders to ultimately produce a work product in the form of this report, making recommendations with respect to ballot access and election integrity.
And is this commission sometimes referred to as the Carter-Baker Commission?
Yes, it is.
in this report, the Carter-Baker report?
That's right.
Okay, so if I use those terms, you'll understand that I'm referring to this commission and report.
I will.
Okay, great. I'd like to turn to page 18 on the on this report, and on the that's page 18 on the internal numbering of the document. Okay, and then this is voter identification. I'd like to go down to the third paragraph on the page. Let me see. Go down a little more. Let me make sure I've got the same. Okay. I'm not sure if this is actually the third paragraph, but the last paragraph on the screen here, the second sentence, says, while the commission is divided on the magnitude of voter fraud, with some believing the problem is widespread and others believing that it is minor, there is no doubt that it occurs. The problem, however, is not the magnitude of the fraud. In close or disputed elections, and there are many, a small amount of fraud could make the margin of difference. To what extent is this statement consistent with the conclusions that you draw in your report?
It is consistent with the conclusions in my report. I see two basic assertions there. One is that voter fraud does occur, that it's a real phenomenon, and that is indeed correct. In particular, I look at evidence of voter impersonation, and I find that there are data sets of credible allegations and prosecutions of voter impersonation that are acknowledged to be incomplete, as any data set of credible allegations of fraud of any kind would be incomplete, which is to say, not representing the whole universe of actual offenses. So that's with respect to the first claim they make. The second claim they make here is essentially that there are close elections in the United States, which is true, and that in some close elections, a small amount of fraud could make the difference. And that's also clearly true. You don't have to look far afield to find examples, including some very striking ones. One that I mentioned in my report is 2017 in Virginia. The control of the state legislature was decided by a lottery in one election in which there was a tie, which is to say, one vote decided partisan control of the entire House of Delegates in Virginia. Does that happen often? No. But we do have instances of small amounts of fraud, in which small amounts of fraud could tip the balance. And the more local the election is, of course, the smaller that amount of fraud would in theory need to be in order to tip a balance, because you would have closer margins and absolute numbers in local elections.
And do political scientists assume that all instances of voter fraud are detected and prosecuted?
No, they do not assume that. This is why there is some political science research that seeks to ascertain the amount of undetected voter fraud. I mean, the assumption of these studies is that there is some amount of undetected fraud, which is why the number of prosecutions and credible allegations, say, chronicled in journalistic accounts, shouldn't be taken for the totality of the voter fraud offenses or voter impersonation offenses specifically. So, for example, Professor Justin Levitt has a well-known data set of voter impersonation, what he calls credible allegations or prosecutions. He's an academic opponent of voter ID laws, but he acknowledges that his data set is incomplete. It's a sample of some size of the amount of voter fraud in the United States.
And you mentioned the Levitt data set. Are there other data sets that you considered in drafting your report?
Yeah, there are three data sets that you find cited. One is the Levitt data set. The other is from the Heritage Foundation. And the other is from an organization called News 21.
And if we could bring up LX90, and this is the Heritage Foundation database. And what is the Heritage Foundation election fraud database?
It's a database, a collection of allegations and prosecutions of voter fraud.
And did you consult this database in conducting your analysis?
It was one of the data sets that I looked at, yes.
And how are the results in this data set consistent with your conclusions?
At the most basic level, the data set is consistent with the conclusion that voter impersonation has occurred in the United States.
And with respect to voter impersonation fraud in particular, is the existing evidence of credible allegations and prosecutions confined to casual or one-off allegations of voter impersonation?
No, what you'll find in the data sets are examples of what is sometimes referred to as coordinated voter impersonation. So this would be instances where you essentially have multiple, what were known in the 18th century or 19th century as repeaters, but you find examples like this in these recent data sets. The one particularly striking example is from New York. It was, I want to, if recollection serves, it was something like 2013. This was in South Williamsburg in New York. And what you have is credible allegations that are recorded in even Professor Levitt's data set, in which you have reports such as, one poll worker indicating that they saw at least 20 to 24 attempts at voter impersonation at a single polling station. The NYPD is called, an NYPD officer witnesses 4 attempts at impersonation within 2 hours. This is serious enough and coordinated enough that this is actually a Democratic primary in which this particular coordination of voter impersonation is happening. So you have a group of Democrats that actually file a complaint about this voter impersonation ring, essentially. And what they say in the complaint is that they allege numerous attempts at underage voting, double voting, and voting under false names. So this would be one particularly striking example in the data set that shows how a coordinated voter ring might work.
Is there any
a coordinated voter impersonation ring? A coordinated voter impersonation ring might work.
And is there any scientific basis for the belief that a coordinated voter impersonation ring would not be possible in North Carolina?
I'm sorry, could you repeat the question, Mr. Patterson?
Yes. Is there any scientific basis for the belief that this type of coordinated fraud that you just discussed, voter impersonation ring committing fraud, would not be possible in North Carolina?
Absolutely not. There's no political science research that suggests this would not be possible. In fact, we know that in North Carolina, you have invalid entries on the voter rolls. Invalid entries, this would be entries of voters who are no longer eligible. And these would provide, and these voter rolls are publicly available. So these would provide opportunities to vote on someone else's record that they will not themselves use. You also have other opportunities that you find mentioned in the political science literature presented by the high rate at which Americans move. Moving, right, eventually will create, if it's a registered voter that's moving creates an invalid entry on the voter rolls. in the state that you're leaving. And so this creates an opportunity for voter impersonation. You also have the Carter-Baker report actually points to the fact that over time in the United States, the average size of precincts has dramatically expanded, right? So the larger these precincts, it stands to reason the less likely everyone knows everyone, which is to say, catching voter impersonation casually would be more difficult in larger precincts. So these are some of the examples of indications of opportunity for voter impersonation. And indeed, in the Crawford case, there is a finding that that the Indiana voter rolls are inflated by as much as 40%. So no is the answer. There's nothing in the political science literature to suggest that coordinated voter impersonation would not be possible in North Carolina.
If one were to assume that we lack certainty about the extent of in-person, or strike that question. If one were to assume that we lack certainty about the extent of voter impersonation, voter fraud, what principle of regulation would support seeking to secure elections through voter ID, if any?
So this is actually a classic situation in which legislators and regulators find themselves, where you have a risk, you're uncertain about the magnitude of the risk. The science with respect to the risk ultimately really can't tell you definitively how significant that risk is. But you have a regulatory decision to make. And this is actually such a common situation in which regulators and legislators find themselves because science is incomplete. This is such a common situation that actually a paradigm of regulation has grown up around it. It's called the precautionary principle of regulation. And the precautionary principle in its more modest form holds that scientific uncertainty about the magnitude of a risk should not be an obstacle for action if that risk is a risk of large or irreversible serious harm, large or irreversible serious harm. So this paradigm of legislation, you could see it work in a number of different contexts, both in the European Union and in the United States.
And what are some examples of other sorts of regulations supported by the precautionary principle?
So one example in the United States would be, and I mentioned this in the report, would be the regulation of bioengineered foods, or GMOs, genetically modified foods. And this is an area where the FDA says, this is a really small risk. We really don't think GMOs are less safe than non-GMOs. The World Health Organization says we're really not concerned about this. But there is scientific uncertainty. There's some level of scientific uncertainty about this. And so some legislators and some regulators have chosen to act in the presence of that scientific uncertainty, given the seriousness of the effects, were the risk to be higher than is supposed by some in the scientific community. So this would be an example of where scientific uncertainty about the magnitude of the risk didn't prevent states like actually my adopted home state of Vermont from banning GMOs, even though the science is uncertain. You can also find examples of regulation in the election administration context that would be very difficult to defend as anything other than applications of the precautionary principle of regulation. One example would be a common regulation, actually, that you can't walk into a polling station with a Biden button or a Trump button. This is a common regulation that you can't do this. Now, this is an imposition on free speech. It's not a major imposition on free speech, but it's an imposition on free speech. So the question then would be, well, is there any strong scientific evidence that states that have these laws that ban you wearing a campaign button in polling stations, are these states less likely to have conflict at the polling station that might disrupt the integrity of an election? And the answer is no. There's no scientific evidence that would suggest that that's a major risk, but there's uncertainty with respect to that risk. And so what have legislators decided to do? Well, they've decided to act in the face of uncertainty about the magnitude of the risk, given the seriousness of the effects. If you were to have, say, a fight break out because of a button, you could theoretically hold up the line for several hours and maybe potentially change the outcome of the election. So here's an example in an election administration context where the precautionary principle makes sense of a regulation.
And in your view, is the enactment of SB 824 consistent with the precautionary principle?
Yes.
I'd like to turn back to the Carter-Baker report, LX1, and back to that same page that we were on, and go up to the second paragraph. It's on the screen now. The second sentence there says, the electoral system cannot inspire public confidence if no safeguards exist to deter or detect fraud or to confirm the identity of voters. Photo IDs currently are needed to board a plane, enter federal buildings, and cash a check. Voting is equally important. To what extent is it consistent with the scholarly literature to say that voter ID laws may inspire voter confidence?
So at the time of the Crawford decision, we actually didn't have political science research on this question. You had an informed expectation that voter ID laws might have an impact on public confidence, but you didn't have research. We now actually have research on this question of the relationship between voter ID laws and confidence in elections. And in particular, you don't have agreement in the research. You rarely do in political science. But we have two studies which I cite in my report, two political science studies, which find a causal relationship between voter ID and confidence in elections. So I would say that there is some scientific support for the expectation that voter ID laws may increase public confidence in elections.
And to what extent does that literature on voter ID laws and public confidence in elections refute the hypothesis that voter ID laws may inspire public confidence in elections?
It doesn't refute that hypothesis because the evidence is mixed. So what you have, to be specific, is you have, and I produce a literature review in my report. You have several studies that are looking essentially at comparing states with and without voter ID laws. North Carolina's voter ID law is not implicated in any of those studies. And they're looking at states with and without voter ID laws, and they're asking, do we find a relationship between voter confidence and the presence of a voter ID law? And those studies, several of them that I cite, they find no relationship, no decrease, but no increase in public confidence tied to the enactment of a voter ID law. Then you also have these two experimental designs, which are the gold standard of isolating causal relationships in social science. And these two experimental designs find that there is a causal relationship. And I'll tell you I'll give you the basics of what these studies find. So one is from the University of New Mexico. It's published by Cambridge University Press. And this study finds that In New Mexico, which had a voter ID law, the ID law was actually differentially enforced. So some voters were asked to show ID and some weren't. And this is very bad news from the point of view of policymakers, but this is actually very good news from the point of view of political science, because it gives you an ability to test what is the effect of being asked for a vote for an ID as opposed to not being asked for an ID at a polling station. And what the researcher finds is New Mexico voters who are asked to show ID are more likely to say yes to the question, do you have confidence that your vote was counted as cast? They're more likely to say yes if they were asked for an ID than New Mexico voters that were not asked for an ID. So this is one experimental result. This would be called a natural experiment, where you find evidence of a relationship between voter ID and voter confidence. The other study is what would be called a field experiment conducted in Virginia. And what the researchers do, one is chair of political science at Northeastern, the other was on faculty at Duke. And what they do is just after Virginia passes its voter ID law, I want to say it's roughly 2014. Just after Virginia passes its voter ID law, what they do is they take a random sample of registered Virginia voters, and they send some of them an informational postcard from the League of Women Voters that gives totally neutral information about voter ID law. Just, sort of heads up, there's a voter ID law in Virginia. And then there's a control group that doesn't receive that informational mailer. And Virginians are randomly assigned to the treatment and control group. So the only difference between them is random assignment to the treatment or control. And what do they find? They find that Virginians who received that mailer and voted are more likely to believe, are less likely, Virginians who received that mailer are less likely to believe there is widespread fraud in the election than voters that didn't receive that mailer. So this is again an indication that knowing that there's a voter ID law may increase public confidence in elections. In this particular case, decrease the number of people who believe that fraud is widespread. So these two experimental designs are notable. Are they definitive? No. But they provide some scientific support for the hypothesis that voter ID laws may increase public confidence in elections.
And have you reviewed the rebuttal report of Professor Ariel White addressing voter confidence and voter ID laws?
I reviewed the section of her report on public confidence.
And how would you assess Professor White's analysis of public confidence?
She also produces a literature review of literature on public confidence in voter ID laws, but her literature review only cites 3 studies, and all 3 studies are aligned with the plaintiff's position on public confidence in voter ID, as I understand it. Whereas I cite, as far as I know, all of the studies on this question, and I show that the results are mixed.
So did Professor White omit the experimental designs that you just discussed?
That's correct.
I'd like to bring the Carter-Baker report back up and now go down to the page 19, which is the next page after the one we were looking at. And I'd like to look at the last paragraph on this page 19. Okay, and so this last paragraph says, for the next 2 federal elections until January 1st, 2010, in states that require voters to present ID at the polls, voters who fail to do so should nonetheless be allowed to cast a provisional ballot, and their ballot would count if their signature is verified. After the Real ID is phased in, i.e. after January 1st, 2010, voters without a valid photo ID, meaning a Real ID or an EAC template ID, could cast a provisional ballot, but they would have to return personally to the appropriate election office within 48 hours with a valid photo ID for their vote to be counted. Do you see that statement there, Professor Callanan?
I do.
Under SB 824, are more than 2 valid types of photo ID accepted?
Yes.
And under SB 824, does the ability of a voter to cast a provisional ballot using the reasonable impediment process and have it count without showing photo ID ever sunset?
No, it's a permanent feature of the law.
And under SB 824, for provisional voters who, instead of using the reasonable impediment process, cast a provisional ballot and return to the County Board of Elections with a photo ID to cure their ballot, how long do they have to do so?
They have until canvassing, which is at least 10 days, I believe.
How would you compare the strictness of SB 824 with the strictness of the voter ID policies recommended by former President Jimmy Carter and the other members of the Carter-Baker Commission?
The Carter recommendation is much stricter than SB 824.
Your Honors, I have no further questions for Professor Callanan at this time.
Right. I guess I forget who would go next, but because Mr. Cox would certainly have the chance to cross-examine. But Mr. Brockman, if you want to go ahead, I'll allow you to begin your cross-examination.
Very good, Your Honor. Thank you. Professor Callanan, can you hear me clearly?
I can.
Okay. I believe you testified on direct, but I just want to make sure I have your testimony correctly, that the denial of certiorari in the HB 589 case was the impetus for HB 1092, the voter ID constitutional amendment, and that the legislature then, in your opinion, had the option to wait for 1 year or to act immediately. Is that correct?
No.
Okay. Do you view the denial of certiorari as an impetus for HB 1092?
I'm not sure I'd use the word impetus. I would say to have passed a voter ID law while you already have a voter ID law might be viewed as duplicative.
I see. So in your opinion, there would have been no need for the legislature to engage with the issue of voter ID until the Supreme Court indicated that it would not take up the HB 589 case in the Supreme Court. Is that right?
I don't think I would put it that strongly. There would be no need, but it's not surprising to find the legislature waiting until they know the disposition of that case.
Okay. And do you know how long after the disposition of that case it was before HB 1092 passed in the legislature?
It was about a year.
Mm-hmm. And are you also aware that 1 day before HB 1092 passed, the Supreme Court issued its decision in the Covington case regarding gerrymandering in North Carolina?
Yes.
And do you view any connection between that decision by the Supreme Court and the legislature's decision to take up the issue of voter ID?
It's not a question I studied, but I do know that if memory serves, June 28th was also the date that they acted on another constitutional amendment that had nothing to do with, voting.
Are you aware, or do you know one way or the other whether the Republican Party expected to retain its supermajority once districts in North Carolina were redrawn, gerrymandered districts were redrawn?
No, I don't know. Not a question I studied.
Okay. So you didn't consider whether the possibility of the Republican Party losing its supermajority following the redrawing of gerrymandered districts was a possible impetus for the General Assembly taking up voter ID legislation.
I certainly considered the possibility, and you would consider this in any instance when you're thinking about a legislative majority. I consider the possibility that the legislative majority decided to act, I'm sorry, the legislative supermajority decided to act while it had a supermajority. But the particular, political calculations, did they think that they were going to lose the supermajority? Did they think it was because of gerrymandering that they would lose it, or because of some other political, wins? That was not part of my analysis. Exactly like what factors, I'm not even sure how you would do that. What factors were in whose head with respect to predictions about the election. But one thing that was reasonable was to not be sure what the outcome of that election would be.
And so in your view and in your opinion as rational actors, it would have been normal for the supermajority to take steps to preserve its supermajority, correct? If it was unsure, I
Yes.
should say.
Yes.
Okay. Are you offering the opinion that a constitutional amendment was required for the North Carolina legislature to enact a photo voter ID law?
No, and I think that is ultimately a legal question.
Okay, you don't see any reason from a legislative norms perspective why a constitutional amendment would have been required in order for the General Assembly to take up voter ID legislation, correct?
That's correct.
Now, I believe you also testified during your direct examination that the legislative process that led to the enactment of SB 824 was, in your view, not aberrational. Is that correct?
I'm sorry, Mr. Brockman, could you repeat that question?
Of course. I believe you testified during your direct testimony that the legislative process that led to the enactment of SB 824 was, in your opinion, not aberrational. Is that correct?
So aberrational is not a word that I use in my report, as far as I recall. The way I characterize it is I say that it's within the range of normal legislative behavior for a legislature in this sort of situation.
And in your opinion, it's within the range of normal behavior because as rational actors, it was rational for the legislature to act while it still had a supermajority, correct?
That's an aspect of my opinion, yes.
Okay. And so because the supermajority was pursuing what, in your opinion, was their rational self-interest, the means by which they did so, acting during the lame duck, overriding the governor's veto, were normal and expected, correct?
I would say that's a simplification of the opinions that I offer.
Forgive my simplification. The rest of it may have gone over my head, but is it an accurate characterization?
I would say it's incomplete, and so in that sense, inaccurate.
Okay. What would you add to make it complete?
Well, what I would add is what I added in what I mentioned in my direct, which is that the alternatives available to the legislature with respect to SB 824, one is hard pressed to give an account of what would have been the more normal route, right? So if you're left with the conclusion that the only thing the legislature could have done would have been nothing, then you find yourself with a conclusion that the legislature the normal thing to do would have been, in fact, something that we don't find legislatures doing in similar situations, which is not pursuing their policy priorities while they have the power to do so.
Right, but it is normal and expected, in your opinion, for legislators and legislators to pursue their rational self-interest and policy preferences while they have the power to do so, correct?
Not unqualifiedly. There are all kinds of situations in which you have real norms, real recognized norms that would lead a legislature to act differently. So this is why I say it's an oversimplification. If you are in the presence of I might give a particular example. Let's say you had I guess I won't give an example, but if you have a particular norm that is, well established, widely recognized, consistently upheld, these are characteristics of a institutional norm, then you may not expect the legislature to act while it has the power to do so. Norms for political scientists do serve as constraints on behavior. So the gist of this aspect of my report is to say, I don't find any norms, and I'm unpersuaded by Ms. Ferris's account or attempt to find norms that were violated in the context of the enactment of 824.
Understood. And let me just try to explore that concept a little bit of this rational self-interest. If you'll assume with me that African American voters in North Carolina reliably vote overwhelmingly for Democratic candidates, you have that assumption in mind?
I do.
Would you consider it to be in the rational self-interest of Republican lawmakers to pursue laws that make it harder for African Americans in North Carolina to vote?
Not necessarily.
Okay, but you might.
I mean, if you found legislators doing that, political scientists wouldn't be shocked to find it. It would be within the range of expected behavior. But it's not to say that legislators, do this often or consistently. There would be all kinds of, in other words, there'd be all kinds of considerations that come into view. One of which would be norms. There may be norms present that would push the legislature in one direction or another.
So just to be sure I have you correctly, it would be within in your opinion, within the expected range of behaviors, normal behaviors for legislators to enact laws that make it harder for African Americans to vote?
Well, you were asking specifically with respect to the rational actor model of politics, right? So you're asking would it be abnormal from the point of view of the rational actor model of politics to find any legislature seeking to discriminate against a particular minority? And it wouldn't be, from the point in every instance, inconsistent with a rational actor model of politics if you have the following assumption, that this is one of the policy objectives, right? So the rational actor model says, given the policy objectives, these are sort of given in a rational actor analysis, the rational actors will respond to the constraints of the choice situation. But you have to assume that they have this policy objective.
Okay,
and I haven't seen.
And I'm just trying to understand the rational actor model is part of your basis for your opinion that what the legislature did in enacting SB 824 was within the range of normal and expected behavior by a legislature, correct?
It's one of the senses in which we can say it's normal and expected, yes.
Right, and that same rational actor model could lead to legislatures enacting laws that target African American voters, and that would be within the range of expected and normal outcomes, right?
If you posit, yes, if you posit that one of the objectives of this legislature, which we're hypothetically analyzing, if you posit that discriminatory legislation is one of their objectives.
And I don't think you dispute this, but I'll ask you to be sure. If African American voters vote reliably and overwhelmingly for one party or another, is it a rational self-interest of a legislature to entrench of the other party to entrench itself by targeting African American voters?
I'm sorry, can you repeat the question?
I can, and I'll try to ask it more clearly. If you assume, as I asked you to, that African American voters vote reliably and overwhelmingly for one party, we'll say the Democrats, is it within the range of rational self-interests for the other party, the Republican Party, to entrench itself by passing laws that target African American voters?
So the rational choice models are not about how political actors choose their ends. It's not about how political actors go about choosing their ends. Rational choice models assume you begin by assuming policy objective X or Y or Z. If you assume they have policy objective X or Y or Z, what would be the range of possible means they might choose? But you posit the policy objective.
Is entrenchment by a political party in control of a legislature within the range of policies that a rational legislature might pursue?
It's within a range that they might, yes.
Okay. And if under that assumption, African American voters, let's say in North Carolina, vote reliably and overwhelmingly for one party, would it be within the range of rational and expected outcomes for the other party to enact laws that target African American voters?
If you posit that objective, then that means would be a potentially rational means to that objective.
Okay. And if, just to complete the thought, if that is within the range of rational and expected outcomes, then a legislature pursuing that goal, under your opinion, would be acting normally, or as we would expect the legislature to act, correct?
If you posit that objective, yes. And if you're abstracting entirely from other potential norms that may be at play.
Okay. Now, in your opinion, the legislative process that led to the enactment of SB 824 was also collaborative. Is that correct?
Yes.
And as evidence of that collaborative process, you rely on the affidavit of former Senator Joel Ford, one of the sponsors of SB 824. Is that right?
That's right.
And specifically his statement that as a Democrat, he had significant influence in crafting SB 824. Is that correct?
That's correct.
And you cite that as evidence that the process was bipartisan and collaborative, correct?
I don't believe I use the word bipartisan. I think I say collaborative.
Okay. Do you exclude bipartisan from your opinion?
I would say it's on the scale of bipartisanship. I mean, it's not at a zero on that scale.
Okay. And so to the extent that it's on the bipartisan scale a little bit, it's Mr. Ford's involvement that you're citing as evidence, correct?
And that's one of the items that I cite as evidence.
Okay. I recall from your direct, you mentioned that you had an opportunity to listen in on some of the testimony in the trial earlier. Did you have the chance to see Mr. Ford's testimony this week?
No.
Okay. So you're not aware then that Mr. Ford admitted during his testimony that at the time he chose to sponsor SB 824, he was no longer caucusing with the Democrats in the Senate?
I was aware he was not caucusing, yes.
You were aware of that
Yes.
at the time you submitted your report in this case?
I'm not sure if it was at the time I submitted the report, but I knew that prior to Mr. Ford's testimony. It may have been mentioned. I think I did at least.
Okay. And
At
does
some
that,
point, I'm sorry, Mr. Brock. At some point, I was made aware of that. I don't recall when.
sure. And does that fact have any bearing or any impact on your opinion that the process by which SB 824 was enacted was at least a little bit on the bipartisan scale?
No,
And why not?
because it remains on the bipartisan scale. We still have an elected Democrat sponsoring the amendment. We still have about 20% of the Senate Democratic caucus that voting for the amendment. We still have the majority of, I'm sorry, I said amendment, the majority of the Senate Democratic caucus who voted. I'm sorry, I'm using the word amendment. So to back up, here's what remains. We have a elected Senate Democrat sponsoring the amendment, although he doesn't caucus with the Democrats. We have 20% of Senate Democrats who voting in favor of SB 824. And we have the majority of amendments adopted to 824 being sponsored by Democrats. So the fact that Senator Ford doesn't caucus with the Democrats doesn't somehow move us to zero on the scale of bipartisanship. We're still on the scale of bipartisanship. Is it the most bipartisan piece of legislation ever passed? Certainly not. But it's on the scale, and you find regularly if you get one or two of the opposite party in the United States Senate to support a bill, the bill gets called bipartisan.
Mm-hmm. Were you aware at the time that Mr. Ford chose to sponsor SB 824 that he had lost his primary election to a political challenger from the left of him and that he had considered switching parties?
I knew the first part, but I didn't know the second part.
Okay. And does the fact that he had considered switching parties have any bearing on your opinion as to the bipartisanship or the collaborative nature of SB 824?
I suppose if I had used, I mean, I don't use the word bipartisan in the report. I suppose sitting here, if we're thinking about that scale, if someone's choosing to, if someone may switch parties, we might come down a notch, but we're still very much on the scale of bipartisanship. He's still a Democrat.
Okay, so we're a little bit on the scale, but maybe coming down a notch. All right, so then you mentioned also that I think you said 3 Democratic senators voted, or I'm sorry, you said 25%, right?
No, I believe I said about 20% of those
20.
who voted for the bill.
Okay, but you are aware, are you not, that Senator Ford was the only Democrat who voted to override Governor Cooper's veto?
Yeah, I am aware of that.
Okay. Now, you also state, I believe, in your PI report, your preliminary injunction report, that the deliberations over SB 824 would have lasted even longer, but for a strategic decision by Democrats to limit participation in floor action. Is that correct?
Do you have a page, Mr. Brockman?
Yeah, I believe it's JX27, and Ashley, if we could bring that up, or Professor Callanan, if you have your report in front of you, I think it's paragraph 28. Nope, I've got the wrong JX number. I'm sorry. JX25.
I see this page you mean. This is paragraph 26 of my
26. Thank you.
June report.
That's exactly right. Thank you for that, Professor Callanan. And you state there, Senator Ford has stated that Senate deliberation on the bill would have been even longer if not for a strategic decision by his own Democratic caucus to limit participation in floor action in order to lay the premises for a legal challenge.
Yes.
And that's based on Senator Ford, former Senator Ford's affidavit in this case, correct?
Yes, I write Senator Ford has stated.
Right. And at some point, either while you were drafting this report or at some point after that, you did learn that former Senator Ford was not caucusing with the Democrats, correct?
Yes.
And did that cause you to question whether Senator Ford was giving a reliable account of what the Democratic caucus strategy was?
I hadn't at whatever moment I was informed that he wasn't caucusing with the Democrats. I don't recall returning to this paragraph. But returning now, I suppose you would say that the further a senator is from, the center of deliberations for his party, the less likely he might be to know the mind of the caucus. Certainly couldn't exclude that that he had basis for this sworn testimony. But I certainly don't cite it as a factual certainty. What is a factual certainty is what I say, which is that Senator Ford has stated that this is the case.
Sure. And did you consider any contrary evidence, any contrary statements regarding the Democratic caucus strategy?
I wasn't aware of any contradictory evidence.
Okay. Professor Callanan, you are also an expert in the federal parallel case to this one, are you not?
That's right.
And in that case, were you aware that another senator, Senator McKissick, who you mentioned during your direct testimony, submitted an affidavit disputing former Senator Ford's statement about the Democratic caucus strategy?
I don't recall that caucus.
Okay,
I'm sorry, I don't recall that affidavit. What I recall from Senator McKissick is his assertion that the process enacting 824 was open and inclusive.
Okay. Let's bring up what's been previously marked as PX 52. And for the record, this is Senator McKissick's affidavit from the federal case, NC State Conference of the NAACP versus Cooper. And Professor Callanan, is it your testimony that you have never seen this before, did not consider it in any way informing your opinions in this case?
I don't recall.
Okay, let's just scroll down and see if looking at any of the substance refreshes your recollection. And let's go down one more page if we can. You see in paragraph 5 here, Senator McKissick states, Mr. Ford stated that it was the strategy of the Democratic caucus to truncate debate on SB 824 and that members of the Democratic caucus intentionally chose not to take the opportunity to debate the bill. The statement is also false and is belied by the legislative record, which reflects numerous floor speeches and amendments offered by Democratic senators in opposition to SB 824.
I do see that.
Okay. And does that refresh your recollection one way or the other, whether you considered this in reaching your opinions in this case?
I don't recall. I'm
Okay.
sorry.
No, that's perfectly all right. It was a long time ago now, I know, and a lot's happened since then. But now that you've seen this statement, does this have any effect on your opinion that the process was collaborative because of Mr. Ford's involvement in his statements?
Well, it's an interesting statement because it actually cuts in both directions, right? So, in the one hand, he's saying, no, it wouldn't have been longer and more deliberative, but for our strategic decision. On the other hand, he's agreeing that there were numerous amendments offered by Democrats. So I think that the statement seems to sort of cut in both directions as to the question of a collaborative process that involved multiple voices.
If we could scroll up just a little bit, please, Ashley. And you see there in paragraph 4, Senator McKissick states that the statement by Mr. Ford that Senator McKissick was happy with SB 824, but political considerations forced me not to be able to support it. That statement was also false. Mr. McKissick goes on to, or Senator McKissick goes on to say, I opposed SB 824 because it is my belief that it is intended to and will disenfranchise minority voters. Do you see that?
Yes.
Does that, now that you've seen that, have any bearing on your opinion that SB 824 was a collaborative process involving many voices based on Senator McKissick's involvement?
That's certainly not new information that a number of senior Democrats in the legislature strongly opposed the bill, and I don't at any point cite, certainly never rely upon Mr. Ford's characterization of Senator McKissick's position with respect to the bill.
You do cite Senator McKissick's statements from the debates on the bill, however, right? You referenced those during your direct testimony, I believe.
I referenced them during the direct testimony, yes.
Okay. And does seeing Senator McKissick's statement that he opposed SB 824 because it is his belief that it is intended to and will disenfranchise minority voters cause you to question in any way whether Senator McKissick's statements during the debate reflect his belief that this was a collaborative process?
No, because the first statement about the process being open and inclusive is a characterization of the process. And this is a characterization of the substance. So it's perfectly consistent to be vehemently opposed to the substance while viewing the process as open and inclusive. It's a rare combination, but that's indeed the combination we seem to find with Senator McKissick.
And you consider Senator McKissick's statements about the bill to be a reliable source of evidence about the nature of SB 824, correct?
Could you repeat the question?
Sure. You consider Senator McKissick's statements about the nature of SB 824 to be a reliable source of evidence about SB 824, correct?
If by reliable you mean, do I think that Senator McKissick's statements about 824 are all true, then no, not necessarily.
Okay. You wouldn't have pointed to Senator McKissick's statements about the collaborative process or the open process around SB 824 if you thought he was lying about that, would you have?
Well, not if I had any, particular reason to think that he was lying. But of course, when you find someone who opposes a bill saying that the process was healthy, that is obviously much more convincing than if you find someone who supports the bill that says the process is healthy. I mean, what you often find in legislative context is people who oppose the substance raise procedural objections. They cry foul on process. I mean, it's actually a sort of, tried and true method. If you oppose the substance, you raise procedural objections to sort of supplement your substantive argument. So to find a senator who opposed the bill, voted against it, saying that the process to enact it was open and inclusive, I found striking. I mean, it's one thing to find, Speaker Moore saying the process is open and inclusive. It's another thing to find Senator McKissick saying it.
Sure. And my question was only whether you had any reason to doubt Senator McKissick's statements. And I take it you did not, based on what you just said.
No specific reason to doubt, his statements, other than the fact that political actors each have their own perspective, and those perspectives are sometimes contradictory.
Sure. And you likewise don't have any specific reason to doubt Senator McKissick's sworn statement under oath that he believes SB 824 was intended to and will disenfranchise minority voters, do you?
I have no reason to doubt that that's his opinion.
Okay. Ashley, we can take that exhibit down. Now, Professor Callanan, you specifically opine that the fact that the legislature acted during the lame duck and overrode the governor's veto while holding a supermajority, it's your opinion that that is not evidence of discriminatory intent. Is that correct?
I would put it this way. I would say that the fact that they acted in the lame duck can be explained in with reference to other factors without needing to reach for unusual causal explanations.
Okay. And it is your testimony, I think we covered this, but just to be clear that there's nothing unusual or unexpected about the legislature's decision to act during the lame duck and override the governor's veto, correct?
I would say I would want to be a little bit more nuanced there. I would want to say, given the context in which the General Assembly finds itself, we only have actually one direct comparator in North Carolina history in which the General Assembly was similarly situated. And in that situation, what the General Assembly decided to do was to act, passing 2 bills in 3 days. So to find the General Assembly again in this situation, which is directly analogous, and to find it acting in the lame duck is not surprising.
Okay. I believe you're aware, I think we talked about this in your most recent deposition, that the North Carolina Court of Appeals issued a decision in this case in February of 2020. You're aware of that, correct?
I am.
And you understand from that opinion that the Court of Appeals concluded the process that led to the enactment of SB 824 was unusual because, among other reasons, the law was enacted by a lame duck Republican supermajority that had lost its supermajority power in the most recent elections, correct?
Yes.
And it's your opinion that the Court of Appeals just reached the wrong conclusion on that, right? They just got it wrong?
I disagree with the conclusion, but I would say more. I would say, if we wanted to find an unusual without respect to context, if we just want to say, abstracting from context, does the North Carolina legislature pass bills often in the lame duck? No, they don't pass bills often in the lame duck. So if we want to just completely abstract from context and define unusual in that sense, then we can do that, and we would say, yeah, this is not something that happens very often. But if we want to look at context, if we want to say, how has the General Assembly acted when similarly situated? How has the General Assembly acted under similar institutional and political circumstances? Again, when a legislative majority is on the cusp of facing a hostile veto pen come January. Well, then what we find actually is that in the only previous instance, they did exactly the same thing. They acted in the lame duck.
Let me stop you right there. It's 12:30. It's time for our lunch break. During the lunch break, or before the lunch break, let me mention a couple things. Ms. Riggs, earlier, I had mentioned that I had signed the party's joint pretrial order in this case. And I think I was in error when I said that. I remember seeing the proposed joint pretrial order. And I remember talking about it at our pretrial conference, I think, but I never signed it. In my defense, one reason for that is that it was sent to me in PDF format, and it did not have a place for me to sign.
That's right.
I don't know if you could email to the Judicial Fellows or to Kelly Myers, either one. I think both of them would be able to get it to me. Maybe that document in Word format, and you can go ahead and take out the word proposed joint pretrial order, and you could just have it as the joint pretrial order. And then you also, if you'd like, could put a signature line down there for me to sign and the other judges. We would then be able to modify it if we need to, and I would go ahead and sign that on behalf of the panel. We've all agreed to it, so I think this is just for the record kind of thing, but it probably does need to be done. So
And
if you want to send that to them, they will then forward it to me, and I'll print it out, sign it, and get it back to them for filing.
we will do that, Your Honor. Thank you. And I apologize about the omission of a signature line. We caught that this morning as well. Just to clarify, once we get back from Ms. Myers the signed copy, should we file that with our first supplemental stipulations as well, so that they're stamped and part of the record?
That would be fine. Yes, ma'am.
Thank you, sir.
All right. Anything else before we recess for lunch? Hearing nothing. We will see you all at 2 o'clock. 2 o'clock. We'll be in recess till 2 o'clock. Have a great lunch.